Hello, this is U.S. Immigration Attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions. Put your questions in the comments now so that I can answer your questions. All right, so today I'm taking questions. That's going to be my focus today. Thanks so much for joining on TikTok, YouTube, Facebook, and Instagram. It's nice to see you here. Come on in, join me. All right, thanks so much for the follow. I appreciate it. All right, so today I'm focusing on questions. It's so nice to see you. Put questions in the comments right now so I can answer some questions. We have about 20 minutes to cover those questions. So go ahead and put those questions in the comments now. Hello there, B-Baddy. My case is not approved yet, filed 13 months ago. So that I don't know what case you have, but it's not surprising that it's been 13 months. It's not out of the ordinary for cases to go more than 13 months. But I would need to know what kind of case are you filing. Thanks so much for the love on TikTok. I appreciate it. Put your questions in the comments. That's why I'm here, everybody. Can my boss file for me if I overstay my visa? It's always best to get a consultation. Your boss should be getting a legal consultation. If you want to understand your rights, you can definitely do an appointment. It's best to call, do an initial evaluation, and then schedule a consultation with us so that we can evaluate, whether it is feasible. But what I would say straight up is once you've overstayed your visa, the chances that your boss will be able to file for you goes down. The longer you're here without your papers is the less likelihood that they'll be able to file for you. And you will also meet up on some obstacles if you've already overstayed. So for one, if you've overstayed, then you will not be able to do adjustment of status. Adjustment of status, and if you've overstayed before you've gotten to file your adjustment of status application, then what's going to happen is you are going to find that you no longer qualify for adjustment of status, because to qualify for adjustment of status in most cases, you must be able to show legal status here in the United States at the time that you filed. If that's not there, then you will not be able to file for adjustment of status through employment. Hi there, Domain. It's nice to see you. Thanks so much for the love. All right. Can I come and meet you directly? So keep in mind, my staff, we have no problems here. I don't know what you mean by that, but my staff answers the phone 24/7, and we're all a team. We work well together. So they will definitely be able to organize an appointment. We do phone and video appointments. And we do represent clients in all 50 states and the globe. Visa overstayed 20 years, no criminal conduct. My mom is scared if she gets arrested. Bond, any options? I know it's a scary time. And yeah, so if your mom is detained, at that point, yes, you would have to look at all the defenses available. You'd have to look, and bond is a possible option for relief, but there are certain requirements you have to meet to even get bond. Being here for 20 years, no criminal record, maybe ties. If you yourself are a US citizen, maybe even having the ties, bond could be a possibility. Getting counsel as soon as possible to go ahead and submit a bond request is going to be essential at that point. Options is going to depend on a number of factors in your mom's background. For example, one such defense to removal is cancellation of removal. If your mom has been here for 20 years, been here continuously, resided here continuously, no criminal record, and in addition to that, she does have strong ties and relatives here that will face extreme hardship if she is removed, then cancellation of removal could be a possibility. But all of this, is it's not happening. So all of that really has to be evaluated by an attorney. If you have any doubts, any questions, any concerns, now is the time to make sure that you have contacted an attorney. You have an attorney on speed dial to be able to call in case you need. Because one thing with our clients who have successfully stayed out of detention, or they've been bonded out, is that they have very quick access to us. So as soon as it's happening, we can jump into action to assist them in this, in that particular situation they're in. So I would say that is a very, very important factor. Thanks so much for the love. I appreciate it. All right. So I'm on YouTube, Facebook right now. So put your questions in the comments. Hello there. If you came here on non-immigrant visa, do you have to register if you're staying over 30 days? So keep in mind that I don't know your case. I'm not your attorney. But generally speaking, if you've entered the United States with a visa, or you were given an I-94 record, then you're already considered registered. So it's unlikely that you would be required to register unless you're coming from Canada and you're planning to stay more than 30 days and you're coming through the border. Hello there, Karen. It's nice to see you. Can you travel to international with dismissed charge? I got green card after case dismissed. It was dismissed, say argument heard, motion granted. So keep in mind that I'm not your attorney. When it comes to travel, it really is on a case by case basis. And I wouldn't recommend you take any advice to travel just by, asking this question online. You need to make sure you're talking to your attorney or an attorney if you have specific concerns. If you have a dismissed charge, it really depends on what the facts are, because even in some cases, dismissals can still be considered guilty under certain circumstances. But here you said you got your green card after the case was dismissed, which means that they should know about it. If they don't know about it, that can be a problem. But if they made the decision to grant you the green card with dismissed charges, they read the facts, they determined there was no conviction and you are not inadmissible, then I would say that they already know it's there. They've made a decision based on that, and so the risk is less likely. I would say if you are traveling and you had a pending criminal record that maybe they didn't know about, that could increase your risk, or that they're just discovering, and they never considered it as part of the determination to give you the green card, then that's where you need to really evaluate your risk. I can't tell you what decision to make, but I can just tell you the facts. And here, I can tell you general information, not even your facts. I can just tell you generally, if they've given you the green card, knowing what they know about the dismissal, then that's an indication that it would be very unlikely they would turn around and use it against you when you're traveling. T visa current wait time, it seems to be taking longer. Should one file a mandamus or just wait? It depends on how long it's taking. If it's outside of processing time, then a mandamus. A mandamus isn't there as a tool to be used. Like if you expected your process to be in a month, that you're going to just start filing suit. And actually, that can be irritating to even the federal court judge if you filed your case and it really is well within the processing times and there's nothing funky about your case or no unnecessary delays in your case, and then you sue to try to get them to make a decision, that can also go left, so when it comes on to filing a mandamus, it's very important that you evaluate. So, like, we look at how long have you been waiting? What's the normal processing time? Is there a reason there's a delay? Or is there something that seems to a procedure or policy that isn't being followed to make the right decision? In that case, those are the things that we consider in regards to when it comes to doing a mandamus. So it all depends. I-864, can a friend who wants to co-sponsor me but is at the same time adopting a child in Africa still be able to co-sponsor me? Will she include that child to her household size? So this is too specific. Definitely talk to your lawyer, because the facts are very complex here. How far are they in the adoption process? Have they adopted the child yet? Have they signed any paperwork? Have they committed to the child? Is the child considered a dependent? All of that will determine whether they have to put the child as a dependent as part of their household size on the affidavit of support. So, as you can see, these are questions that you must refer to your attorney or get an attorney to make sure that it's done correctly. All right. As asylum seeker, hi there, good day. As asylum seeker, after the 150 days pass and applied for work authorization, how long does it take? About 30 days. All right. So I'm on Instagram and then I'm going to head over to TikTok. So hang tight, everybody. Hi there, Shivani. Thank you. I think. Let's see. How long after the prima facie determination letter? So about 2 to 3 months after the receipt notice. Can the green card be approved if me and my boyfriend married, but we're not living together? I'm an international student. My boyfriend lives with his family, so we can't live together at the moment. So here's the deal. The way that the immigration looks at these types of applications, the marriage-based applications, is very traditional. And they expect that if you're married, you're going to be living together. It's they sort of observe marriage here, in the immigration context as you're married, you're living together, you're putting yourselves out there as a married couple, you're building your lives together, you have joint everything or joint as much things as you can have. It's sort of like is an old school way of looking at marriage. Here's the problem with this is that if you and your boyfriend get married, but you're living apart, that indicates to immigration that this is more of a setup than a bona fide marriage because they're like, what's the reason that you're living apart, right? And just hearing that the boyfriend lives with his family is going to definitely raise more suspicions. So what you have to do if you two absolutely cannot live together right now, you need to tackle that issue head on and you need to show all the other evidence for the officer to consider how is it a bona fide marriage even though they don't live together. I don't know if you're in one state or they're in one state, but it looks even worse when you're in the same town and you're not living together. And keep in mind they can still deny this if your boyfriend is just doing this to help you, right? They want to hear this, that you are intending to build your lives together. So you should be showing immigration how is it that what moves are you making to live together? Okay, you can't live together now, but Are you saving money together in a joint bank account? Have you been looking at homes? What's your intention? What are you working towards to be able to show that you do intend to spend your lives together? So it can be problematic for sure. If you're outside of the country and your boyfriend is in the United States living with his family, that's another story. But if you're both living in the same town in the US, you get married, but you have nothing else to show that you're married, you have nothing to show your intentions to build a life together, that's going to be a problem. Are they still approving green card for all categories? That's too broad. Some categories, so for example, SIJS, they've put a pause. Well, there is a hold on that until the end of this fiscal year in October. That those are for abandoned or abused juveniles who are here without either parent. Also, they have put a pause on adjustment of status for asylum seekers and refugees. But to say they've are they still approving categories for all green cards? I think my answer would be no, because some categories are paused, but not all are paused. So, those two are the two that really are on hold right now. My husband is a US citizen. I'm in India. He filed my case online 13 months ago, and my service center is Nebraska. Still not getting any updates when I expect my approval. So I would say anytime now. If your spouse is a US citizen, you should be expecting an approval on that I-130 at any time right now. So it can be, I have noticed 9 to 12 months, but it can go even a little over a year. Hello, I have a case I-130 like 497 days ago. They just said they received after that nothing until now. Yes, that is a possibility. That's not out of the ordinary, unfortunately. And what I can say is processing times may get longer. Right now, just based on the additional procedural steps that they're putting in place for fraud detection. I have a 10-year green card. I have not updated my address with the USCIS in the past few years. Is it too late to change it? I've moved 3 times since I got it. This is where you should always do an individual appointment. What I would say is if you're required to do it, you need to do it. So is it too late? It's never too late to do the right thing, I would say. But I'm not your attorney and I can't give you particular legal advice on the actions you need to take. You need to make that decision, or you have to definitely consult an attorney on it. Aside F1 visa, how can I come to the US legally? I have been denied F1 visa twice. It depends on your circumstances. You're welcome to do a free initial evaluation with us, and we can ask you some questions to see if you qualify for one of the options we help with. So that is a good starting point. So you can go to the link in the profile, go to the profile page on Instagram, on YouTube, Facebook, go to the description in the video. You'll see the link, go there, and then you'll be able to go to the website, sign up to get contacted, or give us a call directly, and we can talk to you, do the free initial evaluation. We run the phones 24 hours a day. That means that we are here 24/7 to answer calls and to help you basically. So, all right. So I'm going to spend these last questions here on TikTok. So go ahead, shoot away those questions, and then I'm going to head out for the day. Hi, if you have a removal proceeding and have I-130 approved, but they cannot close my case. So yeah, that's definitely a complex case. Sometimes you may be able to do adjustment of status in the court after an I-130 is approved, but it depends on a number of factors. Like, do you qualify for adjustment of status? You still do have to qualify. If you're the spouse of a US citizen, your I-130 is approved. that the judge can then complete the adjustment of status through the court process. What about T visa if still approved work permit? So yes, that they have not changed the policy on that. So they are issuing work permits for the bona fide determination, and they upon approval of the T visa, they're issuing work permits. We are seeing it trickle out slowly though, which is a bit frustrating, but they have not changed the policy on that. How long is the wait time for I-765 renewal receipt? So I would say right now everything has slowed down. So I'd say 2 to 12 weeks. Um, why a second interview for I-485? Be careful. If I don't know if this is marriage based, but once you have a second interview for an I-485, that's called a Stokes interview for marriage based, and it's basically a way to. They're basically now screening to see if you are if they're gonna if this is marriage fraud or if it's real. So the stakes get a lot higher here. You have to go in prepared, and you have to go in ready for a very brutal interview. They're probably going to separate you. It's more likely that they're going to separate you and ask you some tough questions. They're going to ask the both of you same questions to see if you answer those questions correctly. So you really have to, make sure you're prepared for it. If you have a removal proceeding, and okay, so I answered that. With a priority date of 2019, how long do you think I have to wait for my interview? You really have to look at the national visa bulletin. That will be able to tell you. I'll give you an idea of the timeline. What means your eligibility notice was mailed? So I'm not sure what. It depends. What application are you talking about? How long is the wait time? So I answered that. What is the process to retain you? Is there a retainer fee? Can I call if arrested? So the yes, we go through a free initial evaluation. We want to make sure we're not wasting your time and money. Once we determine that you do have option that we can help you with, then we go through basically a strategy session with the attorney to talk about how we're going to approach your case, what's the best way to move forward. Then you're issued a retainer agreement and a quote for a flat fee. So we do flat fees here, and we do payment plans as well. So the payment plans range between, I believe, and it depends. It depends on the case types, but we have payment plans that go up to 1 year in payment plans. So give us a call. Let's get started. We move very quickly. So you need to give us a call. Once you give us a call, then my team would be able to do that initial evaluation and get you scheduled in. We are filling up very quickly, by the way. So take action now, because we're very busy. We are getting booked out very quickly. So don't take it for granted. I would say here, the winners are those who are taking action. So make sure that you're taking action to find a solution. Because I can tell you about potential solutions, but you are the one that has to really make the first move. And we really make it easy by doing this free initial evaluation, to just give you the ability to look into this without committing to a fee first. I lost my green card with my wallet. I'm so sorry. I have IR1 visa. Can I file an I-90? Yes. And an I-90 to replace a green card for a lost green card. Yes. If you're going from a 2-year to a 10-year green card, it wouldn't be the I-90, it would be the I-751. If I came on visiting visa overseas and I get married, will I be able to get a green card still? If you got married to a US citizen and you submitted the proper applications and you do qualify in every way, then yes, that is a path to permanent residence. We help with that, so give us a call so we can get started. N400 accidentally put no, I'm a male living in the US between 18 and 26. Is that an issue? It could be. It could be, and I would definitely submit a correction and address that question properly. So make sure you are looking into this. If you were somebody living in the US, a male living in the US between the ages of 18 and 26, then the next thing is, did you sign up for selective service? If not, why not? And that's what you have to do. Thank you for all your support and compassion and answering our questions. No, thank you so much for that. I really appreciate your encouragement. Hello, dear. When your interview was scheduled and your husband didn't come on the interview, what? Then you face denial for sure. If you face, if you do not go to the interview, you need to make sure that you're consulting an attorney. We do help our clients with this. And we've had multiple cases like this where our clients were in a situation where the spouse would not go to the interview, they were being mistreated, and we were able to step in, advocate for our clients, and the USCIS then we help them to switch their process out to a process where they could apply on their own. But you have to take action. And this is where I say here we focus on solutions, but solutions are based on action. So be proactive. If you anticipate that your spouse is not going to the interview, then we need to get to the root of that. Because I know if I had a spouse whose status here in the US was on the line, and that interview, me being at the interview, was going to make sure that they succeeded, I would not miss it for anything. And so if they are not showing up at the interview, that's a red flag for something going on, right? Whether I don't know what's going on, but that's definitely a red flag here. And I've just learned that over time of representing clients in the same situation. And it has turned out well for my clients because they took action before the interview. They sought legal advice and took action. How long we have to find a lawyer after you come and decide to stay here? Talk to a lawyer before you make any decision so that you're making an informed decision. Thank you so much for the gifts and for the love. I really appreciate it. After prima facie is issued, is there usually a biometrics appointment? No green card app was filed yet. So I don't know if you're talking about adjustment of status, but prima facie, usually the prima facie has to be issued after an application is filed. So I'm not sure what this question means here. But if you do have a prima facie and you haven't done your biometrics, biometrics is going to come because that's required. All right. That's going to be it for me today. And let me just see if I see any more questions. And then I'm going to head out very quickly. So let's see. Thank you so much, M. Each. Thank you. Peace to you as well. And what do they investigate for? So how long after prima facie determination letter? And what do they usually investigate for? So prima facie, 2 to 3 months, and I don't know what you mean by what they investigate for. They review the application, they do a background check, look for past immigration violations. Sometimes they can get public record that informs them, confirms things in your application, or even contradicts things in your applications. So you have to be mindful that it's very unlikely that you'll be able to hide anything. Like, they can see a lot, right? So even if you made a police report, but there were no arrests, they can see that. So it's important for you to just make sure that they don't necessarily do a whole investigation, but they do look at your background and make sure it matches up to your application. Can a green card be approved if me and my boyfriend married, but we're not living? Okay, so answer that. Very important. Get help with your process. Not to say you can't live apart and get the green card, but I guarantee if you don't do it right, this is going to be a big problem. Living apart and just applying, living apart, and always make sure you are straight up and telling the truth, because here's the deal. If you they do have ways to find out that you're living apart, so don't try to pretend that you're a married couple that you're not. That's another thing. A lot of married couples focus too much on looking like the other couple, right? So looking like a perfect couple instead of just presenting information about their marriage, being upfront about the reality of their marriage. Marriages aren't perfect. Unions aren't perfect. The way you may organize your marriage may not be traditional, and you need to make that clear, right? And the officer then can consider it in that context. Hello there, Alicia. What does a VAWA petition need to do if a derivative is close to the age of 21? VAWA was filed December 2024, derivative turned 19. So here's the good news. Once you file for VAWA and your child is under the age of 21, it freezes their age for immigration purposes. So for immigration purposes, they will always be 19 years old, right? So once you file, so that's another reason why it's very important to take action, because as you can see here, if you have children that are depending on you to file on time and not so they don't age out, then you need to do it right then and there, because it can freeze your child's age. I applied through March 2020, got denied, then applied for VAWA and got prima facie. Will I get an interview? You may. So VAWA applicants are getting interviews. So, be if you do get an interview, just prepare with the VAWA interview. What they're looking at is everything you've said in your application true? And did you submit all of this information? Because they're finding that there are people that are submitting fake VAWA applications. Fraud has become very prevalent in the VAWA process. And so this is their way of being able to determine whether this person truly qualifies for VAWA, and whether they are aware of the information that's in the application, and whether it appears to be true based on the applicant. You think I can still get a marriage-based green card with a dismissed petty theft case, only an arrest for possession? So your case is complicated, and I would say this: whenever we're dealing with criminal issues, we have to advise very carefully. Now you said possession, which makes me think arrest for possession means controlled substance. When you have a controlled substance, then that is definitely a big red flag in immigration, and it's not necessarily to say you're automatically barred. However, there could be the consequences could be significant, right? If you end up going to an interview and you are inadmissible, you could be arrested right on the spot and detained. So you want to make sure that you fully understand the consequences of the arrest. If there's no conviction, sometimes being able to have an immigration attorney advise can help even your criminal attorney set the tone for a plea deal to maybe reduce the charges. But you have to you get in touch with us. We're definitely going to we have to look at your arrest record. We have to look at the court records. We have to look at the facts. We have to look at the state statute to be able to advise you about what the consequences are going to be. So do that now. Get in touch with us. We definitely help with this, but you need to get in touch with us so we can do it. My husband is a US citizen. I'm in India, so I answered that. So here's the deal also. If you did not have a conviction, it was dismissed or a case dropped or it was not filed, then it means there's no conviction. And the law does state that in order for the inadmissibility to take effect, you have to actually have the conviction on record. Then it means that you have to show immigration there's no conviction, and immigration will be able to then not, they can't use that against you. However, keep in mind, possession again, oh, it's such a scary word in immigration. Possession is a scary word because keep in mind that they do have, immigration officers do have the discretion to say this. Um, Even if your case was dismissed or they never brought charges for possession, they can also find, based on the facts of your case, that they have reason to believe that you're a drug trafficker, right? Just depending on the facts, how much of the drugs was there any intention to distribute the drugs? They can look at the police report, and they can and there is no conviction required for that one. And why is that scary? Because once you have that, they have a reason to believe that you are a drug trafficker. They can then turn around and bar you permanently from getting your papers, getting a visa, or getting your green card. So, this is once again, when it comes to criminal issues, it's so important to get advice, because these are the things that can happen if you don't tread carefully and understand the consequences involved. Thank you so much for the love. I appreciate it. And I love the questions so much. These are all great questions. I end up staying, and because I find these questions irresistible. My hyphenated marriage didn't come on my I-130 approval letter. Will it be an issue? So I'm not sure. I'm not sure what that means. Applied for my green card, had an interview, didn't he slip by? Just got an email, my case open back up. Applied for my green card, had an interview, didn't, I'm not sure what that means. I don't know. Applied for a green card, had an interview, didn't slip by, but got an email about my case open. So if they're reopening your case, I'm not sure if they approved it and then they turned back and reopened it, or it was closed, they denied it and they're reopening it. I'm not sure. I would really have to understand the facts here, but definitely you can schedule an appointment with us and let's talk about the facts here. Marriage issues. Can I divorce my wife after receiving a 10-year green card? If you are having, it is your right. If you want to be able to move forward with your life, it's just a situation you can't be in. Divorce is an option for you, right? And after having the 10-year green card, that means you don't necessarily, the next step is citizenship. You don't have to be with your spouse to get the 10-year. And even if you have marriage issues and you had a 2-year green card, but you were having marital issues and you're divorced, you can still get the 10-year green card. So looks like you'll be okay if you get divorced. But if they're keep in mind, I'm not your attorney and this is not legal advice, it's general information. If you're worried about a particular thing in your background, it's that's where the responsibility is yours to seek legal advice, and that goes for all the questions here. I've recently married and have a new stepson. What form do I start filing to adjust their status? So it depends on where they are. Are they in the US? And really, it's not about filing forms. It's really the forms is information, but you really have to understand the legal requirements. And I think, especially now where the cases are going to be a lot more complicated. So that's where I can't just say, start with this form, because it really isn't about that. If I tell you to go fill out a form, you're sure to run into a lot of problems. So definitely give us a call, schedule, do the initial evaluation, and then we can talk to you in a strategy session about the process based on your particular facts. I would be doing you an injustice just telling you, file this form when I don't know your case, don't know the facts. And the attorneys here at ST Law Office are experienced, and that's what we do in the strategy sessions is we go over what we're going to do, what actions we can take, the requirements are to be able to move forward. How long does it take to receive my green card after getting my work permit and doing biometrics? It depends on the type of green card. Why does T visa case number not work? Because it's highly confidential, so they really don't want to publish it online. They don't want to risk any complications, any unauthorized individual checking the status of the case. What's the processing time for marriage-based green card now in 2025? So I'd say it's still 10 to 12 months right now. All right, that's going to be it for me. Thank you, everybody, for joining me. I will be coming back tomorrow. So, what I say, like, subscribe, follow, hit the notification bell. That's how you're going to see when I come on, and then you can join me if you're available. Also, all lives are replayed or they're saved on YouTube. So, one way to be able to catch past lives is to join us at YouTube. The channel is Getting the Green Card on YouTube. You'll be able to then check out all the videos that are posted there. And we do have long form videos that talk about different subjects that's not posted on Instagram or TikTok or Facebook. So you can also go there to watch other longer form videos that talk about processing times. VAWA gets into detail about the T visa and policy changes. So thank you for the follow, everybody. Just hang tight and remember, we're about solutions here. There are solutions. We have been seeing certain victories in court. Unfortunately, we have seen that the Supreme Court has said that the administration can terminate TPS for Venezuelans. And so we're going to be seeing a lot. If they do move forward with it, which they have tried, then we are going to be seeing a lot of immigrants who have legal status now lose their status. And I would say this, it does not mean that they have no options, but now they have to look at what other options are available. Because going back to Venezuela also is not really an option. It is not a stable country. Many of them were targeted and persecuted. And I'm pretty sure that as you're listening to me talking about what the Venezuelan community is worried about, many immigrants, that it's the same issue all across the board. So if you want to find options, solutions, that's what we're here for. And we are helping our clients. We're changing lives. So we're going to keep doing that. Get in touch with the team here at SC Law Office. We have attorneys here, experienced attorneys that I work very closely with that can talk to you after you go through that initial evaluation to make sure that you do qualify for assistance. So give us a call. We're 24/7. The number is going across the screen, and you can also go to the website. And if you click on the website, you'll see the number and you can sign up for us to give you a call. We're a safe space, but we need you to reach out. Okay. And everything is confidential. So hang tight, everybody. Take care. And everything is about solutions. So let's take action towards that. Bye bye.